The phrases thing of value and anything of value are broad and inclusive enough to encompass at least some forms of valuable information. Throughout the United States Code, these phrases serve as terms of art that are construed broadly. United States v. Nielsen, 967 F2D 539 542, 11th Circuit, 1992, per curiam, thing of value includes both tangibles and intangibles. See also e.g. 18 U.S.C. 201 B1666 A2 bribery statutes. ID 641, theft of government property. For example, the term thing of value encompasses law enforcement reports that would reveal the identity of informants. United States v. Gerard, 601 F.2D 6971, 2D Circuit, 1979, classified materials. United States v. Fowler, 932 F.2D 306, 310, 4th Circuit, 1991. Confidential information about a competitive bid, United States v. Matskin, 14 F.3D 1014, 1020, 4th Circuit, 1994. Secret grand jury information, United States v. Jeter, 775 F.2D 670, 680, 6th Circuit, 1985. And information about a witness's whereabouts, United States v. Schecker, 618 F.2D 607, 609, 9th Circuit, 1980, per curiam. And in the public corruption context, thing of value is defined broadly to include the value which the defendant subjectively attaches to the items received. United States v. Renzi, 769 F.3D 731 744, 9th Circuit, 2014, internal quotation marks omitted. Federal Election Commission (FEC) regulations recognize the value to a campaign of at least some forms of information, stating that the term anything of value includes the provision of any goods or services without charge, such as membership lists and mailing lists. 11 CFR 100.52 D1. The FEC has concluded that the phrase includes a state-by-state list of activists. See Citizens for Responsibility and Ethics in Washington v. FEC, 475 F.3D 337 338, DC Circuit, 2007, describing the FEC's findings. Likewise, polling data provided to a campaign constitutes a contribution. FEC Advisory Opinion 1990-12, Strub, 1990 WL 153454, citing 11 CFR 106.4b. And in the specific context of the foreign contributions ban, the FEC has concluded that election materials used in previous Canadian campaigns, including flyers, advertisements, door hangers, trifolds, signs, and other printed material, constitute anything of value, even though the value of these materials may be nominal or difficult to ascertain. FEC Advisory Opinion 2007-22, Juris, 2007 WL 5172375 at 5. These authorities would support the view that candidate-related opposition research given to a campaign for the purpose of influencing an election could constitute a contribution to which the foreign source ban could apply. A campaign can be assisted not only by the provision of funds, but also by the provision of derogatory information about an opponent. Political campaigns frequently conduct and pay for opposition research. A foreign entity that engaged in such research and provided resulting information to a campaign could exert a greater effect on an election and a greater tendency to ingratiate the donor to the candidate than a gift of money or tangible things of value. At the same time, no judicial decision has treated the voluntary provision of uncompensated opposition research or similar information as a thing of value that could amount to a contribution under campaign finance law. Such an interpretation could have implications beyond the foreign source ban. See 52 U.S.C. 30,116a, imposing monetary limits on campaign contributions, and raise First Amendment questions. Those questions could be especially difficult where the information consisted simply of the recounting of historically accurate facts. It is uncertain how courts would resolve these issues. Number 2, willfulness. Even assuming that the promised documents and information that would incriminate Hillary constitute a thing of value under campaign finance law, the government would encounter other challenges in seeking to obtain and sustain a conviction. Most significantly, the government has not obtained admissible evidence that is likely to establish the scienter requirement beyond a reasonable doubt. To prove that a defendant acted knowingly and willfully, the government would have to show that the defendant had general knowledge that his conduct was unlawful. U.S. Department of Justice, Federal Prosecution of Election Offenses 123, 8th edition, December 2017. Election Offenses, see Blumen 800 F Sup, 2D at 292. noting that a willful violation requires proof of the defendant's knowledge of the law. Danny Eltzik, 917 F sub 2D at 577, knowledge of general unlawfulness. This standard creates an elevated scienter element requiring at the very least that application of the law to the facts in question be fairly clear. When there is substantial doubt concerning whether the law applies to the facts of a particular matter, the offender is more likely to have an intent defense. Election Offenses 123.